Happy Friday and welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville and Associates Senior Principal and Senior Estate Planning Attorney Olivia Holcombe-Volke. I'm Jeff Stauffer, Community Relations Director with the firm, and I'll be moderating today's event. How this will work today, if you haven't joined us before, if so, welcome. We're glad you're here. You as the attendee are on mute. However, you do have a voice. When you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. You also received the presentation this morning from me by email for your convenience to take notes on it if you wish. Also, for CFPs and CPAs and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. For attendance records requirements from me, please email me your board ID. And for CFPs as well, I need the last 4 digits of your social security number as soon as possible so I can get your CE approved. Everyone will also receive a post-webinar feedback email right after the presentation. And we kindly ask that you please take just a couple minutes to fill out this simple survey to offer us your valuable feedback about the presentation. It's also a great time to request a consultation with Olivia for any planning needs that your family and you may have. And I will also remain on the webinar afterwards for a few minutes if you have any remaining non-legal questions as well. So briefly, I'd like to share an overview of our firm and some background about Olivia before we get started. If you're not familiar with us, we were founded in 2010 in Columbia by President and Managing Principal Stephen Elville in 2010. We have a number of different practice areas here: estate and special needs planning, elder law and elder care planning, estate and trust administration, business and succession planning, asset protection, guardianship, a very busy litigation department, and tax planning. We have 7 attorneys, 12 staff members in 5 locations. We're primarily working from our Columbia location right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of very best superior legal technical knowledge. We offer a lot of education here at the firm. We offer that through our planning processes with our clients. We offer over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. We're one of the only firms in the state of Maryland, probably maybe 1 or 2, that offers an accredited client care program through the Client Care Academy in Boston, Massachusetts. We also follow the ideals of client education, collaboration, and compassion with every client, every time here at the firm, every day. So you should expect nothing less from us anytime that you work with us here at Elville and Associates. It's my pleasure to also welcome Olivia Holcombe-Volke, Senior Principal and Senior Estate Planning Attorney with Elville and Associates. Olivia's work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. I've known Olivia for many years, and she is just one of a kind. I've had her work with my family for our planning needs and wouldn't trust anybody else with that. So she is a seasoned speaker. Each year presents at numerous workshops, conferences, and continuing education events. Named to the Maryland Rising Stars list by Maryland Super Lawyers in 2017. 10 Best for Client Satisfaction in Estate Planning by the American Institute for Legal Counsel in 2018 and 19. And we're very proud of Olivia for all the volunteer work that she does in the state. A board member for the Women's Law Center of Maryland, a volunteer attorney for the Maryland Volunteer Lawyers Service, and also a founding member of the MVLS's Community Advocacy Network, Volunteer of the Month in May 2019. And she also provides free trainings to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So you're in very good hands with Olivia today, and I'm going to go ahead and turn it over to her. Before we do that, though, I'm going to offer a brief poll just to get an idea of what's brought you here today to learn about special needs planning. And that question is, to get to know our audience, please tell us what has brought you to today's webinar. I'm going to go ahead and launch that, and you should see that on your screen right now. And the responses that you can choose from, choose the best one that applies to you, is I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited. Third, I'm a financial advisor here to learn to benefit my clients. Or four, I'm an interested family member here to gather information. So choose the best one that applies to you so we can get to know you a little bit. And we'll get started. Looks like the votes are coming in quickly. I noticed in the registration we have a lot of new attendees here, so welcome everybody. And with most of the votes in, we have 64% saying I need to set up planning for a loved one with special needs, 9% saying I have planning in place but it needs to be revisited, another 9% saying I'm a financial advisor here to learn to benefit my clients, and 25% saying I'm an interested family member here to gather information. So thanks for participating. And with all that being said, I'm going to go ahead and turn it over to Olivia. You've come here to learn from and hear talk instead of me. So Olivia, you should see that button pop up on your screen.
Excellent. Thank you, Jeff.
I'm going to turn off my camera so I'm not a distraction. It's all yours.
Thank you so much. So let's go back a step there. Good morning, everyone. And as Jeff said, happy Friday to you. I'm Olivia Holcombe-Volke of the many, many services that we offer at Elville and Associates. One of the ones that we are the most proud of and that is the most fulfilling is the area of practice of special needs planning. And that's what I'm going to focus on today. What families need to know about planning for a loved one with special needs. There is a lot of information to cover. I will not go over every slide in detail, but our goal is that by providing you with the information at your fingertips, it will stimulate your awareness of the different details and aspects that we want you to be aware of, and to bring you into a conversation with me or with one of our other special needs planning attorneys to really be able to focus on your specific situation. So of course, as an attorney, we always need to start with the disclaimer. The information in this presentation is meant for education and not to be considered specific legal advice. So, why plan? The purpose of planning for a loved one with special needs is multifaceted, but at its core, it's about enhancing that person's quality of life to the maximum extent possible, while also protecting them. And protecting them means different things for different individuals. It may mean protecting them against the risks of outside influences or people who may take advantage. It means protecting their ability and eligibility to receive certain government benefits and assistance. It may mean protecting them against themselves. All of this is done within the context of not wanting to take away someone's autonomy and not wanting to take away someone's enhanced quality of life, but to maximize that to the greatest extent possible. And that's what special needs planning is all about. The benefits of planning are many, and that's true across the board. As an attorney, I will always tell you a plan is better than no plan, and a written plan is really what I'm talking about. But the benefits of planning, in part, and especially when we're talking about planning for a loved one who does have special needs, the idea here is that you are planning in order to provide financial security, to leverage as much as possible any government benefits they may be eligible for, to make sure that to the greatest extent possible, you have selected the appropriate team of people to be a part of your loved one's life for lifetime management and assistance in whatever way it may be that they need, to plan for their future housing that's appropriate for their needs, to provide for an ongoing system of advocacy. Think of this as you are planning for a time where you may no longer be able to provide everything that you have been providing. So you're setting up a plan to ensure that there are future people around who will be able to maintain and continue to do all that you have been doing while you've been able to. This includes planning for caregiving needs that your loved one may have, coordinating with all other family members or loved ones who may have an interest in providing for your special needs loved one, financially or otherwise, to make sure that you've done everything that you can to protect the beneficiary, meaning your special needs loved one, from predators, and to preserve assets as much as possible, if this is part of your goal, to preserve assets as much as possible for other people and other heirs after your special needs loved one passes away. So part one is, how do we create an effective plan for a loved one with special needs? What does that look like? The steps that I recommend that you start as soon as you can are to put yourself in the shoes of envisioning your loved one's future, and especially thinking about that in terms of you no longer being here. So planning ahead allows you to have the time to think through all of these details, to think about where your loved one will live, and to potentially discuss that with the individuals with whom you might want them to be able to live, to think through what level of care may be needed, whether a guardian may be necessary, and what the steps are for that to be accomplished, who all should be involved, what kind of lifestyle do you want for your loved one, what future challenges should you think about and anticipate and plan for. It allows you to build the layers and to understand the full process and purpose of planning. Creating a memorandum of intent. This is one of the most significant tools in special needs planning. This is sometimes known as a letter of intent. What this is and what that means, the way that I always describe this to people is, this is you putting in writing all of the details that you think are important for a future person to be aware of with regard to your loved one. Whether that's things that bring them joy, things that upset them, medicine that they absolutely have to have, who their caregivers are, who their doctors are, what their hobbies and interests and activities are, what foods they really like or don't like. All of this information that's in your head, but that may not be known by someone else. And in the event that you're not around to communicate those things that you know and to ensure that those things that you know are done, this is your way of putting that in writing to provide that information to future caregivers or other family members or anyone who may be a part of your loved one's life in a future where you are no longer around. The steps that you should take today include thinking about the financial aspect of things, estimating what the income will likely be that your loved one will receive or be eligible for versus the expenses that they will have. What does that financial picture look like? And only by doing that will you have any realistic possibility of being able to determine how much money you need to plan to leave for your special needs loved one, and to be able to talk to your financial advisor, to your special needs planning attorney, to any other expert to determine What are the ways in which I can, as much as possible, plan for there to be sufficient money available for my loved one, taking into account their possible income and expenses? The next few pages are meant to give you a helpful worksheet to be able to do that sort of thinking about expenses and then income. Part 2 is talking about what are the public or government benefits that are a relevant part of the conversation when we're talking about special needs planning. Briefly, public benefits, government benefits, are broken into several different categories. One category, which is called means tested, and this, of course, is reliant in part upon a person's means, by which I mean what money is available to them, what assets are available to them. Means tested public benefits are SSI, which is Supplemental Security Income, and Medicaid. Entitlement public benefits, which are something that someone is entitled to because they have either contributed money from their own work and employment, or they have a connection to someone else who has contributed money through employment to these particular systems. Entitlement public benefits are Ssdi, which is Social Security Disability Insurance, and Medicare. And then there are other benefit programs that are always part of the conversation, such as Section 8 housing and sometimes veterans benefits. So supplemental security income, SSI, what is it that you actually get? SSI is intended to pay for food and shelter. That is what that money is intended to be used for. In 2021, the federal benefit rate for SSI is $794 a month. There are some states that do supplement this amount. And this amount does vary depending on the individual's living arrangement or if in fact it's an eligible couple. In order to qualify for SSI, an individual must meet two tests. One is that they are either medically disabled or elderly, which is defined under Social Security law as above the age of 65. And the second test, because remember, this is a means tested benefit. The second test is that their assets and income fall below the allowable threshold. This is measured in two ways. There is the resource test and there is the income test. The next slide gives you a bit more information about how disability is defined by the Social Security Administration, which is the relevant definition when we're talking about disability as one of the tests to be eligible for SSI. The SSI resource test, countable resource limits currently. And this is, I must always emphasize, obviously all that we can ever do is talk about current law, current rules and regulations. We really have no ability to predict what they will be in the future when it may be applicable to the person that you're planning for. And this is why, in large part, it's so vital that you keep your plan updated. You create a plan based on what we currently know, but you must revisit it over future years in order to make sure that it's current with what the current and applicable law may be in the future. But under current SSI regulations, countable resource limits are $2,000 for an eligible individual and $3,000 for an eligible couple. But not all resources are counted. So there are some assets that an individual or a couple may have that are exempt from consideration for the SSI resource test. The SSI Income Test pivots on 4 different types of income. These are all defined on the following pages, but the 4 types of income that Social Security defines and considers for the SSI Income Test are earned, unearned, in-kind, and deemed. What happens with the income test is that the countable income is ultimately subtracted from the federal benefit rate in order to calculate that individual's benefit amount. As I say, here are some further definitions on how these different types of income are defined. So switching to Social Security Disability Insurance, SSDI eligibility. Here, we're not looking to means. This does not pivot on someone's available assets. 2 tests to qualify for SSDI. One is disability. And here we look to the same definition as on the prior slide that's set forth by the Social Security Administration. But the second test is sufficient work history. So remember that I said that SSDI is an entitlement benefit. So this is based upon sufficient work history where money was contributed to the SSDI system. SSDI does not have a resource test. The benefit amount is based on past wages. After 24 months of receiving SSDI, an individual receives Medicare. And it is possible in some circumstances to receive both SSDI and SSI. Something that is called the Childhood Disability Beneficiary, or sometimes known as the Disabled Adult Child, DAC benefit. This is a Social Security benefit for individuals who were disabled before the age of 22 and have an eligible parent based upon the parent's work record who are now retired, disabled, or deceased. In these circumstances, the disabled adult child benefit will be available. Receiving these benefits may reduce or eliminate SSI benefits. This also has no resource element to it. It does not pivot on someone's resources. And also with this one, after 24 months of receiving the DAC benefit, the eligible beneficiary will also receive Medicare. So now talking about Medicaid and Medicare. Medicaid, again, is a means-based benefit. It is meant to cover medically necessary services and preventative care, and it does have a benefit to provide for skilled nursing. Medicare, which is an entitlement benefit, is medical coverage. It's basically like health insurance for those who are entitled to receive it. Medicaid is automatically available for someone who qualifies for SSI. If someone qualifies for SSDI or just Social Security, they have to apply separately for eligibility to receive Medicaid. Medicare, as I previously mentioned, is available after 24 months of receiving Social Security disability insurance or the disabled adult child benefit. Section 8 is specifically with regard to housing, which of course is a source of great concern for many families planning for their special needs loved one. This is something where this is just a part of the conversation that we have with our clients, talking about all the different facets that they need to think about in terms of their loved one's future and all the different details that play a role in that. So there's a bit more information about that here. More information can be found at the HUD website. So now switching gears and talking specifically about special needs trust planning, sometimes known as supplemental needs trusts. Those terms are one and the same. They mean the same thing. So if you hear supplemental needs trust or you hear special needs trust, they do mean the same thing. Where they are different is set forth here. And the differentiation between the types pivots primarily on the idea of a third-party supplemental needs trust versus a first-party supplemental needs trust. The difference between those is in the name. Third party means that someone other than the beneficiary, so anyone other than the special needs beneficiary, created the third party supplemental needs trust, and the money that goes into it comes from any other source other than the special needs beneficiary, him or herself. So anyone else can establish it, anyone else can contribute money to it. And the purpose of it is to provide for money to be used for the special needs beneficiary for their lifetime, and at their death to go to the remainder beneficiaries, which have been determined and dictated by whomever created the trust. The difference with a first-party special needs trust is that it is created by the special needs beneficiary, and it holds the money from the special needs beneficiary, him or herself. This type of trust is also intended to be used over the course of the special needs beneficiary's lifetime, but at their death, the first place that the money that may be left in the trust has to go is to pay back Medicaid, to pay back the government benefits that may have been paid out for that special needs beneficiary. Then any money remaining after that point can go to the remainder beneficiaries as dictated by the special needs beneficiary. So a first party trust is a way for an individual who has too much money, too many assets of their own. It's a way for them to put that money into a first party special needs trust so that now they can be eligible to receive government benefits. But the trade-off is that when they die, the first place that the money gets paid back to is Medicaid. There are two types of first-party trusts. One is an individual first-party trust. This falls under the federal code that's set forth at D4A, and that's why it's called a D4A trust. A different type of first-party trust is known as a pooled trust. And this is where it's more than one individual beneficiary contributing their money to this pooled trust for investment and use by a nonprofit trustee is typically in charge and oversees the pooled trust. And the reason that a pooled trust is typically used is either because the disabled beneficiary or the special needs beneficiary is now beyond the age of 65, or because there is a rather small amount of funds going into the pooled trust. So focusing on utilizing a third-party special or supplemental needs trust. This is the best mechanism for providing an inheritance for a special needs individual in a structured way, while also protecting their eligibility for any government benefits. Again, this is called a third-party supplemental needs trust because it is established with the assets of someone other than the loved one with special needs. And what this accomplishes is it's a mechanism, a vehicle for holding the money that will be inherited by the special needs beneficiary. It will hold that inheritance. It will be used only for their needs, only for their benefit, but it will not be considered their asset. So for means-tested government benefits, this is not considered part of their means. So it protects their eligibility for government benefits, and if the special needs beneficiary is subject to creditors' claims or potentially vulnerable to predators, the money in the third-party special needs trust is protected against those threats. Something that I hear people talk about that I never recommend. People have such good intentions, and many times what they are thinking is, I have a special needs person that I would like to leave money for, but I know that they can't manage money on their own, or I know that they're receiving government benefits that would be ruined if I left them money. So what I'm going to do is something different. I'm either going to not leave money to them at all. I'm just going to disinherit them and not leave money for them at all, even though I really want to, and even though they could really use it. Or I leave it to someone else with the understanding that they will use it to take care of my special needs loved one. Or I leave it to them outright, and they'll have it and they'll use it however they need, and I'll just leave it to them outright. Or leaving it in a trust that doesn't qualify as a supplemental needs trust. None of these are things that I would recommend. If you leave the money directly to the special needs person, they may lose government benefits that they're currently eligible for, or that they might be eligible for in the future. The same thing if you leave the inheritance to a trust that is not specifically a supplemental needs trust. This can also cause them to lose their benefits or ruin their potential future eligibility for those benefits. Disinheriting them is certainly not doing them any good. And the risks with leaving money to another person with the gentlewoman or gentleman's understanding that they'll take care of your special needs loved one. Now you have opened the door to the risk that that person gets sued or divorced. And now the money that you intended to be used for your special needs loved one is lost to that other person's divorcing spouse or creditor. Because guess what? That money that you left to them is considered their money. And so it can be taken by their creditors. And further along that same line, if that person then dies, that money is part of their estate and it will go to wherever their estate goes. So all of these, even with the best intentions, are not arrangements that I would recommend if you want to leave an inheritance for a special needs beneficiary. The main requirements for a third-party special needs trust, again, the beneficiary or the beneficiary's spouse did not actually create the trust. The trust does not actually hold any of the beneficiary's own money or own assets. The beneficiary cannot be the trustee, and the trustee must have total discretion regarding whether to distribute or hold money from the trust. Most families do prefer to utilize third-party trusts. First and foremost, everyone likes the fact that there is no payback requirement, that the money in the trust will be for the benefit of your loved one for their lifetime, but when they die, it will go to other people that you want to provide for. You get to dictate that. And there is no payback requirement at the death of your special needs loved one, where Medicaid gets to claim any money out of the trust come to them. The additional nice thing about third-party supplemental needs trusts is create one as soon as possible, but we can make it revocable. So as long as you're still alive, you can make changes to it. As the future comes and as the laws change and as your preferences change, we can make it revocable. So creating a third-party special needs trust right away does not mean that it's set in stone. We can write it in such a way that it will become set in stone when you die, and there are other parameters that we can put into it. But until then, you can make changes to it. But the good idea about doing it sooner rather than later is that you don't know when you're going to die. So you'll have it in place so that it's ready to go the instant it needs to be utilized. And another good thing about a third-party special needs trust is that there is a lot of flexibility and a lot of available options to you in how it's written. And so we can go into comprehensive planning for how you want trust money to be used, what you want to be done with the trust money in terms of your special needs loved one, and just all sorts of details that we can build into it to accomplish your goals and intentions. One of the biggest and hardest decisions to make is who the trustee should be.
Olivia,
Yes.
before we dive into that, can I ask you a couple of questions?
Oh, please, Jeff. Yes.
Is that a convenient time?
Absolutely.
Okay, great. Thank you. So first question is, how does someone switch from SSI to SSDI benefits as a CDB when a parent retires? If receiving SSDI, can the special needs person still work as a nominal non-supporting job?
So what I would say about this is that the answers to those questions are, how does someone switch? Well, it's a matter of going through the necessary application to Social Security, and can someone still receive SSDI and work? I believe that the answer to that question is yes, but I will tell you that we on our staff, one of our principal attorneys is the expert in the specifics of Social Security, disability, and SSI. And her name is Megan McCullough, and she helps with actual applications for the Social Security benefits and is able to answer questions about the particular nuances in terms of those benefits and switching from one to the other. So I would say that's a question that Megan would be able to answer. And if you'll write down that person's information, Jeff, we can get more detailed information for them.
I will certainly do that. And actually, it looks like that is the only question for right now. Please, anyone having any questions, please note them in the questions panel, and we'll be sure to get them to Olivia. Thanks very much.
Thank you, Jeff. So when we're doing trust planning, anytime we're doing trust planning, part of the decision making is the appropriate person to name as the trustee. And thinking about this again as this is the person who will be in charge of the trust, which is the money. So this is the person who will have to make determinations and decisions about investing, distributing money from the trust, also making sure that the annual tax return is filed, that any eligible government benefits are not messed with by actions taken by the trustee. All of this can be very complicated. And so the right decision about the trustee can also be very complicated. Many people think either a family member or maybe a professional or their attorney, they think about those different categories as maybe this is the appropriate source for naming the person to be the trustee when I'm no longer around and I can no longer act on behalf of my special needs loved one. So this is a part of the counseling conversation that I have with people because it is a complicated decision to make. And in large part, the right decision depends on the specifics and the particulars of your situation, your special needs loved one's situation, the money that's going to be going into the trust, and the family that we're talking about. So this is just an important part of the conversation when you're building a special needs trust. One of the great things about a third-party special needs trust is the ability to include a lot of additional, more comprehensive provisions in terms of how the money should be used and who should be involved in the decision-making. So some of the things that I go over with clients when we're reviewing a third-party supplemental needs trust that they're putting into place are the ideas of using and including in the trust document something called a trust advisory committee and also something called a trust protector. Now, the purpose to a trust advisory committee is primarily to provide the trustee with help in making certain decisions about the appropriate use of trust money. But the trust advisory committee can also be utilized to make sure that the trustee is acting appropriately or doing a good job. So a trust advisory committee is something that I always recommend that people include in their third-party supplemental needs trust. Typically, my recommendation is that it be included as an optional provision, that it can be utilized if it ends up being necessary or a good idea. The trust protector is a little bit different. The trust protector is somewhat in the name. The purpose of the trust protector is to protect the trust, by which I mean their purpose is to make sure that the trust continues to function in accordance with your intentions in creating the trust in the first place. So the idea being, you create a trust under current law, knowing current realities. What if there are changes to that in the future? Changes to the law, and now the way that the trust is written is out of sync with the new law. The trust protector can amend the trust just to keep it current with modern law in order to make sure that it continues to function in accordance with your intentions. What if the trustee can no longer serve? They're not able to do so because of death or incapacity, and now there's a vacancy. Well, the trust can't function without a trustee. The trust protector can make sure that a new trustee is named, again, in order to make sure that the trust continues to function in accordance with your intentions. A trust protector can also remove a trustee if a trustee's not doing a good job or is mismanaging or just not doing a good job. The trust protector can oversee that and make sure that the appropriate trustee is in place in order to make sure that the trust functions in accordance with your intentions. So trust advisory committee and trust protector are things that I highly recommend that we include in a third-party special needs trust for all of these reasons. The contemporary structure of a special needs trust plan includes the trust advisory committee, the memorandum of intent, the trust protector, the trustee, an advocate for the special needs beneficiary. This is something else that we can build into the special needs trust. There are certain special considerations that we have to take into account if part of what you're going to do is leave retirement plan money to this trust. And for some families and for some special needs beneficiaries, an ABLE account should be a part of the overall plan. And that's all part of the counseling and conversation that I have with clients who wish to implement a special needs trust plan. I mentioned before, but here again, a trustee is basically the person who is in charge of the trust, which means they are in charge of the trust assets. So their job can be very complex. It depends on the situation. Some third-party special needs trusts are not overly complicated. The situation is simply not an overly complicated one, but other times they can be. And so this is part of the conversation that we have to have in order to be able to determine the appropriate person to name as the trustee. Is the appropriate person a family member or friend, or would it really be better for it to be a professional? Because their job can be complex to make sure that the moving parts are understood and appropriately handled in terms of the special needs beneficiary and their needs, their eligibility for government assistance, the government assistance benefits and the eligibility requirements, the amount of money that's in the trust and the lifetime needs and expenses that the special needs beneficiary may have, the appropriate investments to make with the trust money in terms of that, the appropriate ways in which to use the money because of that consideration, and of course, keeping records, making sure that there's documentation to show accountability, and filing an annual tax return. So a trustee position can be a complicated one, and it should all play a role in the decision as to the appropriate trustee to name. A third-party supplemental needs trust can pay for pretty much anything. It depends upon how you've written the trust, but the way that I always describe to people that a trustee needs to think through whether or not to use trust money to pay for something, what I recommend, or the way that I outline it, is this. The first step is for them to identify, what does the special needs beneficiary need? What are their financial needs? The second step is, what government benefits are they receiving, or could they be receiving if we just applied? And what is it that those government benefits pay for? And what is it that those government benefits are meant to pay for? And then looking at the difference between what the beneficiary needs versus what they're receiving from the government to pay for. And the remaining needs, those are the supplemental needs. And that's where the trustee has discretion to decide, is using money from the trust to pay for that supplemental need a wise decision? The question of how much and which assets to use to fund a third-party special needs trust, I would say that most people do fall into two groups. Some people come in and it's very important to them to make sure that all of the beneficiaries they're going to leave money to are treated equally. So it's kind of an easy decision, split it. But other people are very focused on the fact that their special needs loved one will likely need more money because of their inability to work. And so this is all just a part of the conversation as to the appropriate way to split or otherwise fund the supplemental needs trust. And then we talk about the appropriate assets to be used to fund the trust. Should life insurance be used? Should retirement assets be used? Those have specific tax considerations that we have to talk through. All of this really benefits from having a good financial planner or financial advisor on board. So if you don't have a person of that type as part of your planning team, I recommend that you do. And I have many good resources and referrals that I can provide if that's something that you need. First-party special needs trusts, I'm not going to go over in as much detail, but again, to try to make it clear what a first-party special needs trust is. A first-party special needs trust is a trust that is utilized when there is an individual who otherwise would qualify for a government benefit, but they have too much money, they have too much in assets to qualify for that government benefit. In that case, one of the tools that we have available is to create a first-party special needs trust. The individual puts their assets into it. Now they have a low enough asset base to qualify for the government benefit. So that's why we utilize first-party trusts. The idea is that the money in that first-party trust continues to be used to pay for what the beneficiary needs. Again, the money is meant to supplement the government benefits they're receiving. There are more restrictions on what is allowed to be paid for from a first-party trust, because at the termination of the first-party trust, which is at the individual's death, Medicaid has the right to seek payback from any money remaining in the first-party trust. Medicaid has the right to seek payback for the money that they spent on that individual. So the first step is that Medicaid has the right to seek payback if there is money remaining in the first party trust when the individual dies. And any money left after that can go to whomever the first party trust says it goes to. But part of the reason that there are more restrictions and more specifics about how money from a first party special needs trust can be used is because because Medicaid has the incentive at the end for there to be money left for them to be able to get paid back. So there are more restrictions on how first party special needs trust money can be used. First party special needs trusts are commonly used when someone who's receiving government benefits that they will lose because now they have too much money. Maybe they receive a personal injury award or an outright inheritance or gift, or they recently became disabled and that was an unexpected thing to happen. So in all of these circumstances, the path forward may well be to utilize a first party special needs trust in light of money that's come in that was unexpected or disability that's come in that was unexpected.
So Olivia, we have a few questions that have come in. Is now a good time to pause for a few minutes?
Absolutely. Thank you, Jeff.
Okay, great. And just going back for a moment, the question from the gentleman, if receiving SSDI, can the special needs person still work at a nominal / non-supporting job? I did receive that feedback from Megan, who said, yes, they can still work and receive disability, but there are very strict rules regarding how much an individual can earn. And further, she said the information is available at ssa.gov and that they will want to look at the rules surrounding substantial gainful activity and the trial work period. So Andrew, the gentleman who asked that question, I will email this answer to you so you can look further into that. So I hope that's helpful to you. And so with that being said, our next question, I believe, is also from Andrew, which is what is the triggering event for a child's eligibility for the monthly SSI benefits, i.e., would a 7-year-old with working parents currently be eligible?
That is another question for Megan. I apologize, Andrew, but the specifics of eligibility for the Social Security benefits is really something where I'll have to defer to Megan's input on that.
Okay, very good. And so we have a few that have come in here. Let me make sure I get to the top here. Next question is, are there special considerations for third-party special needs trusts as a beneficiary of a pension / IRA plan? There is a potentially large required minimum distribution and high trust tax rate if income is not distributed.
That is exactly right. That is exactly right. And so that is part of the conversation about when someone is creating a third-party supplemental needs trust, we have to talk about what else they're planning for. So are there any other beneficiaries that are part of their plan? There are people who do not plan to leave their estate to anyone other than the supplemental needs trust for the benefit of that beneficiary. But some people have multiple beneficiaries that they're planning to leave their estate to. So that's the first part of the conversation. The second part of the conversation is, what are the assets that you will be leaving? And then we have to do an analysis of, is it best to leave these particular assets to these particular beneficiaries and these other assets to these other beneficiaries? And that requires an analysis of all of the assets that you have and your intentions at death as to one or more beneficiaries. But you're absolutely right as to the reason that it is something that must be analyzed and something that must be discussed is because what we're talking about is qualified retirement assets, which means that the money in that asset has never been income taxed. If that money, that asset, is inherited, there are still income tax considerations that have to be taken into account and that are different depending on the actual beneficiary. So a new law passed at the end of 2019 that has greatly changed and impacted how inherited qualified retirement assets are treated in terms of income tax. And it depends upon the beneficiary. There are different categories of beneficiaries that have different treatment in terms of inheriting from a qualified retirement asset. And when we're talking about a third-party supplemental needs trust, and when we're talking about the beneficiary of a third-party supplemental needs trust, there are different tax considerations that have to be taken into account, including a trust's tax rate, meaning a trust's income tax rate, versus the individual's income tax rate, and whether the individual qualifies as what's called a qualified disabled individual, because not all third-party supplemental needs trusts are for someone who actually qualifies as a disabled individual. It's usually thought of as a supplemental needs trust is only utilized for a disabled individual, but that's actually not always the case. Again, a third-party supplemental needs trust is used primarily to protect someone's eligibility for government assistance, and that doesn't always necessarily fall in line with disability to the extent that's necessary to qualify as a disabled individual under the Secure Act and the IRS terms. So I'm very long-winded in answering this question. My best answer to you is that make sure that's part of the conversation that you are having with your special needs planning attorney. Make sure that if you are a financial advisor, that is something that you are tipping your clients off to as something that has to be dealt with and addressed very carefully. But the answer to the right path is there is no one right path for every situation. We have to talk about all of the details that go into it. But it's a very relevant part of the conversation.
Thank you, Olivia. Very well said. Next question. If I create a special needs or supplemental needs trust for my son who is 6, can it be revoked or terminated if his development far exceeds current expectations?
Absolutely. So again, one of the things that I said previously is the idea that if there is any worry or any thought that someone that you love and that you intend to provide for from your estate, if there is any thought or concern at this point in time that a supplemental needs trust is going to be the right vehicle for their inheritance, do it sooner rather than later, because you don't know when you're going to die. But what you do, and what I always recommend that people do, is we create that as part of your estate plan now in case you die. But over time, as things change, we update your estate plan and change those things and change those plans if those future changes warrant a different plan. So that's why it's important that when we write a supplemental needs trust, part of the conversation that I have with people is, let's make it revocable so that if there are changes in the future, you'll have an easier time of making those changes or revoking that trust completely. But yes, I would say that nothing is really set in stone until until death and until something becomes irrevocable. And even then, we do have, under the law, we do have ways in which we can work based upon changes in circumstances. In large part, that trust protector plays a big role in that.
Okay, those were all the questions for now. Thank you, Olivia.
Okay, thank you, Jeff. So now I'm going to talk about decision-making and capacity, and thinking in terms of the special needs individual and their decision-making ability and their capacity to make their own decisions. And with that, what we're talking about is planning for the possibility of incapacity, or if someone has incapacity currently, what can be done. So planning for incapacity, if we're thinking about that in terms of planning for the possibility of future incapacity, here, one of the things that we have available to utilize is if someone currently has legal capacity, which means that they are over the age of 18 and they have sufficient mental capacity to sign legal documents. In that case, what I recommend for everyone, this goes beyond just a special needs individual, this is for everyone who is over the age of 18 and has mental capacity to sign legal documents. You need to plan for the risk that there will be a future where you are incapacitated. And the way that we do that is by signing documents called an advance directive and financial power of attorney. And what we're doing with those documents is saying, if I ever need someone else to act for me with regard to my health care or with regard to my assets and my finances, this is the person I'm giving permission to do that for me. I'm choosing who will act on my behalf if I ever need them to, for my health, for my money. So this is what we utilize in order to protect against what happens when there is someone who is incapacitated, meaning they do not have the mental capacity to sign legal documents. For someone who does not have the mental capacity to sign legal documents, therefore they are incapacitated. What happens is that there is a court process called guardianship or conservatorship, where the court actually verifies that the individual does not have sufficient legal capacity, mental capacity, and that they need a guardian. They need someone to oversee their health and their physical well-being. They need someone to oversee their finances and tax returns and that sort of thing. So someone who has legal capacity should sign an advance directive and financial power of attorney so that if they ever become incapacitated, they will not be subject to a court-ordered guardianship. But someone who is currently incapacitated, who is not able to sign an advance directive and power of attorney, then the appropriate mechanism for stepping in and making sure that you can act, or that the appropriate person can act on behalf of that incapacitated individual in terms of physical well-being and finances, is to seek court-ordered guardianship and conservatorship. Those terms are interchangeable. Frequently, guardianship means physical and conservatorship means over the finances. Now, there is something that's happening that's very exciting in special needs law, and that is the evolution of the recognition that just because someone has special needs does not mean that they are entirely incapacitated or entirely debilitated, that they in fact should still be able to play a role in decision-making about their own health and about their own money. And this is called supported decision-making. And this is something that is on the books, meaning it's in the laws in some states. In Maryland, it's not yet here, but we're certainly working toward it. But again, the idea here is special needs law has evolved a tremendous amount over time. We've come a very long way in recognizing the autonomy and supporting the autonomy of special needs individuals. And supported decision making is just one further step in that direction. So at age 18, as I said, an individual is presumed to have legal capacity, but if they lack mental capacity to sign the necessary legal documents to give someone the ability to act on their behalf, or if they lack the actual mental capacity to manage their own physical and financial well-being, that's where a guardianship or conservatorship may be necessary. Of the person, so guardianship of the person means of physical well-being, physical and healthcare and education, all of those things. Of the estate means of the finances and legal affairs and tax affairs for that person. So making decisions about the future. Recommendations. Meet with me or with a special needs planning attorney for a consultation to talk about your particular circumstances, your goals, your concerns, your assets, and the person that you want to plan for. Part of this is doing an analysis of your current estate plan if you have one, certainly talking about implementing the appropriate plan right now for whatever your goals, concerns, and assets are. Part of the conversation is, and part of what I recommend that you think about is, do you have the appropriate team of advisors, which includes not only a special needs and estate planning attorney, but also a financial advisor and tax advisor. Thinking through your goals and any questions or concerns that you have, these presentations, these webinars, do a good job of hopefully wetting your whistle as to the different things that you need to think about and the different things that you may want to think about. But of course, it's impossible for these to answer every question that you have and to really focus on your particular circumstances. So come have a meeting with me so that we can talk through all of that in more detail. The steps for planning toward the future: establish an estate plan. If relevant and applicable, establish a special needs trust. A memorandum of intent is going to be vital. Thinking through future financial needs, that's vital, and planning for that appropriately to the greatest extent possible. Having an awareness and understanding of what government benefits we're talking about and what your particular loved one or the particular situation, which of those government benefits are relevant to that conversation, and what do those government benefits require? What are the rules and regulations and nuances to that? And making sure that anyone that you do plan to name as a trustee has some familiarity with that, has some advance awareness of what they're going to need to know and be aware of. And start thinking through the appropriate people to name, to advocate and be a part of the life of your loved one in a future where you may no longer be around. Maryland Able, this is something that there are many slides here that are meant to be provided to you for your information and for your ability to be aware of Maryland Able and to potentially pursue further information from the actual ABLE program that can answer a lot more of your detailed questions. So I'm not going to go into too much detail other than to say, please see these slides and please reach out to the ABLE program for more information. But a brief statement on what ABLE is. ABLE stands for Achieving a Better Life Experience. And what this is also a rather new thing, and again, an example of the evolution in special needs law. But the idea with ABLE is that it is meant to be a savings account where a special needs individual can actually contribute their own money to their ABLE account, and the money that's in the ABLE account won't be treated as theirs for the sake of eligibility for means-tested benefits. So previously I talked about a first-party special needs trust sometimes being the appropriate planning tool when we're talking about an individual who otherwise would be eligible for government benefits, except for the fact that they have too much money, they have too much in assets. A first-party special needs trust is sometimes the appropriate solution, but sometimes an ABLE account is the appropriate solution. And more often than not, all of it is the appropriate solution. So an ABLE account is the savings account that an individual is allowed to put money into without having it knock them off of eligibility for means-tested benefits. But there are a lot of rules and regulations with regard to how much money can be contributed, how much money can accumulate, and how money from the ABLE account can actually be used. So the next few slides give you a lot more information about ABLE, but that's my general overview on what ABLE is. And that's all that I have to cover today. So I hope that that was helpful. As I say, for particular questions about actual applications for Social Security benefits and how all of that works out as to your specific situation, we have an expert as part of our team at Elville and Associates who actually helps people with applications for Social Security, helps people with appeals when they're denied their Social Security. And Megan is really going to be able to answer any questions that you may have about specific Social Security questions. And she's part of our team. I'm here to help you plan appropriately for someone who does have special needs that you want to prepare for a future where you may no longer be around, and you want to make sure that any money that's being left for them will be used to the best extent, maximum extent possible, while also protecting their eligibility for government assistance. Jeff, any further questions?
Well, thank you very much, Olivia. Well done as always. I appreciate your time and your expertise and knowledge. Doesn't look like we have any further questions at this time. For everyone out there, now would be your time to get those last questions into us. While you're doing that, I wanted to mention regarding the Maryland ABLE program, we have a really strong relationship here with Maryland ABLE and have been very fortunate to grow that relationship over the last several years. Kelly Nelson, who is their outreach coordinator at Maryland ABLE, presents with our webinar series a few times a year, and actually just last week offered a very terrific program about Maryland ABLE and all of the slides in that presentation. So what I'll do in my follow-up email to this webinar is I will include a link to that video for that webinar for your convenience. And we appreciate Kelly always allowing us to share her slides in our special needs planning presentations. She's a wonderful resource, as you'll see in the video if you like to watch it. Her contact information is knelson, KNELSON, at Maryland, spelled out Maryland, ABLE, ABLE.org. So any questions about Maryland ABLE, you can reach out to them. Just let them know that Jeff and Olivia at Elville Associates sent you their way, and Kelly will take very good care of you, I can assure you of that. So, and in my follow-up, I'll also provide Megan's contact information for any SSI, Ssdi issues or concerns or questions that you might have as well. So it looks like we have another question that has come in. Thank you for that. And the question is regarding, can we email a fee schedule for our firm's services? Olivia, is that something that we typically do? I think we can do that, yes?
Oh, certainly. So
Yeah.
the answer to the question is our fee schedule is absolutely information that we are more than happy to share. But what I will also say is what I always want to encourage people to do is to take advantage of the fact that the first consultation with me would be free. So having a meeting to be able to talk about your particular needs and then to be able to tell you on the fee schedule what it is that I recommend that you need or should do, and then you have a better idea of what the fees that are actually applicable to your situation might look like. And then we have the ability to talk about it. So certainly that's fine, but know that the first meeting is a free consultation in order to really figure out what your fees would be to accomplish what I would recommend for your plan and your goals.
Right, and everybody's situation is slightly different, and so that's why we offer customized planning here at the firm. So,
Exactly.
and let's see, have somebody saying, thanks, Olivia, for all the information, very helpful. I hope to contact you for a consultation. Well, thank you very much. Doesn't look like that was a question, but a comment, so we appreciate that. And so no further questions, it looks like, at this time. So I will say we thank you for attending as always and for your support of our Elville webinar series. We're going to be staying pretty busy here through the end of January, and February is a very busy month for us. If you go to our website, elvilleassociates.com, and click on our events calendar, you'll see a lot of events taking place in February. Rounding out January, we have a new webinar taking place offered by our elder law attorney here at the firm, Lindsay Moss. On Tuesday, she's going to be offering a webinar about Medicaid long-term care asset protection planning, a very specialized topic, but important topic for many. That's next Tuesday at 10 o'clock. So you probably have received an invitation about that. If you didn't, you can see that on our events page on our website and can register for that there. So with all that being said, see if we have any last questions. Some more thank yous, Olivia, and I thank you as well. And appreciate you being here today, and hope you have a really nice weekend. And we appreciate your interest in Elville & Associates and your support of our webinar series. So have a great day and a nice weekend, everybody. Take care.
Thank you. Bye.